Thank you for the introduction and kind invitation. So I will have a completely different view on national sovereignty. I will look at it from the prism of international commercial arbitration, and we will see the role of international obligations and how it shapes this relationships between the state and the arbitration. So thank you for my colleagues that previously covered the national sovereignty concept. So I'll just have a broad outlook on that. Then I'll have the crash course on international commercial arbitration because it is really important for me that you all understand what arbitration is. So my point would be then taken. Then we'll look at the waiver of a recourse to a court. We will look at the Switzerland's approach. We will also examine the ECHR's perspective on it and the academic debate. So just to put it simply, so we see that national sovereignty, well, basically states' independence and authority to govern their jurisdiction as long as it corresponds to international obligations. I don't want to kind of cover it anymore because it was well explained prior. What I want to focus on is arbitration. So let's look at this picture that I made. So, for example, you have an enterprise in the US, I don't know, for example, Alex, and other enterprise in China, Yudong. So, and they have long-standing business relationship, but as life happens, the dispute arises. And in their contract, they have an arbitration clause, which says, okay, if dispute arises, we need a neutral venue or a place, and it would, for example, be Switzerland. So Swiss jurisdiction then would apply, and then we need a neutral third party, which would be arbitrator, for example, from Brazil. And then arbitrator rules in favor, for example, for Yudong, and then Yudong goes with this award and tries to recognize and enforce it where the Alex has resources. For example, let's take Jamaica. So it goes to Jamaican court and tries to recognize it, whilst Alex is trying to annul or set aside the award at the Swiss court. So here, what is important is the concept of party autonomy. So parties have the power to rule on how they want to conduct the arbitration. So it's complete freedom. They can choose which jurisdiction they want, etc. So that's a key notion here. It is also, we have in, academia, a debate between localized and delocalized approach. Localized saying that arbitration is inevitably tied to some sort of jurisdiction in one way or another, and delocalized speaks about a national approach that arbitration is not rooted anywhere and it shouldn't be rooted anywhere. So importantly is lex arbitri, which is basically if we say that Swiss law applies to our procedure, we cannot, as a parties, deviate from the mandatory laws. Even though we have party autonomy, we cannot deviate from those mandatory laws, for example, public policy. So that's on arbitration. So regarding a waiver of a recourse, so this was my research question, which is whether a waiver of a recourse to a court against arbitral or award, which is basically a set-aside, which contains inalienable rights and which is made in advance under Article 192.1 of PILA, is compatible with the ECHR. So in short, it's basically whether parties can waive non-waivable rights. So kind of naturally, the answer would be, oh, well, they cannot. But the answer finds itself kind of in conceptually murky waters, and we see here the state's power to expand party autonomy, and we want to find its limits within the confines of international obligations such as human rights. So looking at the Switzerland, so it establishes a waiver of a recourse in Article 192.1. It established it with the two main legitimate aims. First being that it wanted to be more attractive as a seat, and to increase the efficiency of arbitral proceedings. And the second one was to mitigate the administrative burden of the tribunal um, that basically receives these set-aside submissions. So you don't really need to read the article. You need to focus on the preconditions for valid waiver. So first is territorial detachment, and the second one is express agreement for this exclusion agreement. So, and we find the problem in the second precondition, which is basically prior to 2005, there was a strict interpretation. So basically, tribunal said that there should be a specific reference to the set-aside grounds and to the Article 192. So there would be no doubt that parties actually intended to waive such rights. Now, Switzerland exercises liberalized interpretation, so it only views this waiver of a recourse through a linguistic interpretation, and it is much more a relaxed approach. So looking at the ECHR, so through its case law, it impliedly establishes that non-waivable rights are independent impartial tribunal and a right to fair hearing. So because they create rule of law and democratic apparatus. So the conditions for a valid waiver under the Article 6.1 of the ECHR is free will, unequivocal manner, that the minimum safeguard should correspond to the waiver's importance, and it should not go contrary to the public interest. So the Suvaniemi and others versus Finland case, even though it concerned a procedural estoppel, it also applies to exclusion agreements, which basically the court basically said that as the parties were aware of the circumstances that established the rigged procedure, but they chose then to waive these rights, the waiver was okay. It is important also to acknowledge that high contracting parties do not necessarily quash their obligations to ensure that the fundamental rights are protected. So you establishing a waiver of a recourse within your legislation, you do not quash your obligation to, for example, provide these minimum safeguards. And let's look at the Tabanes case. So Tabana entered into joint venture contract with French company. The contract contained arbitration clause, which basically did not establish a seat and said basically that arbitrators should decide on a seat. But it also included a waiver of a recourse. And then the tribunal decided that the seat would be Switzerland. And it also decided in favor of a French company, and of course, Tabane filed a set-aside claim. However, the tribunal said, well, you have a waiver of a recourse, which is valid, therefore it's inadmissible. The same was held also at the European Court of Human Rights, that the submission was inadmissible. There are a lot of critique regarding the court's reasoning. Maybe the two main ones was the unequivocal manner. So court basically said that there is this party autonomy, contractual freedom, etc. So the parties themselves mandated arbitrators to choose the seat. So basically Tabane submitted, well, we didn't choose Switzerland, how could we know it, etc. So here the concern was that parties didn't choose Switzerland willingly. And for unequivocal manner under ECTHR, it is really important under the case law that you have a conscious decision. So it is not really conscious in that regard. Regarding minimum safeguards corresponding to the weight of the waiver, the court said that the tribunal provided Tabane with well-reasoned decision why the set-aside claim was invalid. But here we really speak about the minimum safeguards at the time when the waiver is made, not when, for example, if Tabane wouldn't have gone to the tribunal, would there be minimum safeguards then? So there are a lot of questions in that regard. So there are 4 camps of thought when we speak about waivers of a recourse of inalienable rights. So the first one says that there's a party autonomy and parties can do whatever they want. They can also waive inalienable rights. Then there are those who say that no rights should be waived in principle. Some say that, well, if they are non-waivable rights, they cannot be waived. And the fourth camp that I attach to is that, okay, if you really want to waive your fundamental inalienable rights, you could do it only post factum. So it's Germany's approach. So if you truly intend, for example, you know that your a procedure was really rigged, but you just want to finalize it and you don't really care, then you will have your true intention for it to be waived, and it would be unequivocal then. So it goes to the notion that if you give parties such a freedom, you as a state, you are responsible to supervise these activities. For example, let's imagine if a state is a owner of a property and you have a sandbox there. And you know these 2 random kids that are not your kids come by and say, oh, I want to play in that sandbox. And you say, okay, go and play. I don't really care because you're not my kid, but you're aware that you have some sort of nail sticking out and whatever, and you don't say to them that. I mean, is it really a minimum safeguard then? Not really. If you say, okay, just be aware that I have this waiver of a recourse, if we speak on the matter. Okay, and if they make a decision, okay, I will go irrespectively, then it should be okay. And coming to the conclusion, so we really see the both nationally and supranationally that party autonomy levitates also beyond the convention. And the Switzerland's tribunal also has said in its case law that when parties make this waiver of a recourse, they cannot ask for a court to also review fundamental issues as issues of a rule of law. So you really then see that party autonomy really levitates beyond states and beyond even convention. So I have one critique also towards the administrative burden, and maybe just to make a comparative example. So in Latvia, Latvia's regulation until July recently did not possess a set-aside mechanism at all. We didn't have that in our regulation. And we had a case before Constitutional Court, which basically said that it infringes human rights. You cannot just not have a regulation. So it would be then the parties waive on the basis of a regulation, not on the basis of exclusion agreement as in Switzerland, but choosing the seat as Latvia, where it doesn't possess a set-aside mechanism, they would impliedly then choose this. And the Constitutional Court said, well, you should have set-aside provisions as such. So yes, this would be it from my side. Thank you.